All right. So, without any further ado, I will be introducing my partner, Jeremy Schwartz, and he's going to tell you how to draft the perfect employment contract that will never get challenged in court. So, here's Jeremy.
Thanks, Landon. So should I just run before I have to fill that order that you just wrote for me? All right. So for those of you who have been to our conference before, welcome back. For those of you who this is a new event or who haven't attended HR conferences before, I have the unfortunate task of walking you through some bad news, but also trying to help you to avoid that bad news being sort of personalized. So Landon has set me up to succeed. I'm going to take you through the pitfalls to avoid and some drafting errors that other employers have made, and we can learn from other people's mistakes so we don't have to make them ourselves. And then there will be a quiz, both for the at-home audience and for the folks here. And that quiz is going to be in the lightning round at the end of the day. I have 7 minutes, and we're going to see how much you absorbed during this presentation. I'm going to show you a number of different clauses, and you guys are going to vote on whether you think the judge would have found this enforceable or not. And we're going to see how well I present and how much you guys have learned. So employment contracts are one of those fraught areas where everything seems simple. And the number of clients that I have had who have said to me over the years, why don't people just live up to the bargains that they've made? Why do we bother having employment agreements if everyone's going to challenge them, right? It seems like, what's the point? Well, the point is, if you've drafted them well, when somebody breaks that agreement or tries to prevent you from enforcing your agreement, well, you have the upper hand. You have the leverage. When they send a demand letter, you can say, well, actually, here's the enforceable clause in our contract, but you know what? We'll give you a little bit of money, nominal amount for a release, or else if you don't accept that, you can feel free to sue us, but you're not going to win. And you'll be able to say that feeling sure, unless the sea changes and the law changes and shifts again, and what was enforceable yesterday is not enforceable tomorrow. That can happen. Unless that happens, you'll feel confident that your contract is good, that you're in the right because you were upfront with your employees. You weren't trying to trick them with the language that you've chosen, and that they knew what they were getting into if they read it before they signed it. And that's how contract law should work. And as people in HR and as an employment lawyer, I just think that's what's fair. Right? It's not fair to try to hoodwink someone out of their rights, but if you're upfront and you're clear and everyone knows what is expected and what is being agreed, that everyone should honor that. That's how rule of law works. We live in a democracy, right? So, what are the objectives of employment agreements? Protect the employer, incentivize the employee, right? After all, this is a document someone's going to see before they come and work for you. To a certain extent, it's a recruiting tool, right? If it comes off as a 15-page, heavy-handed, only employer-friendly document that makes them think you want to fire them a week after you hire them, maybe they're not going to think this is a great place to work. Clarify and define expectations from both sides, right? We want everyone to come into this relationship knowing what it should be. Right? You work, we pay you, here are the other perks, but here are our expectations in exchange for this deal. And of course, to avoid litigation. So Landon, what Landon said is that your agreements after my session will never be challenged. I would prefer to say not successfully challenged. So my goal is to help you guys to recognize issues in your contracts or in your practices that if your agreement were challenged or your practice in recruiting were challenged, you would be able to say to the judge or to the lawyer sending a demand letter, actually, we've got it right, you've got it wrong, and we're not interested. Okay. So the 3 pillars of employment contracts, and these ionic columns of every contract hasn't changed in thousands of years. Like this is how contract law works: offer, acceptance, consideration. And it seems straightforward and simple, but often when one of these pillars isn't there or it's not set on firm foundation, the contract will fall apart. And sometimes people don't realize that there's an issue with one of these pillars until it's too late. And you can't squeeze one of these pillars, which is foundational, under your contract after the fact. So you've got to get it right from the start. This is the support for the legal sort of structure that you're building. So new contracts for current employees. Okay, so you guys are all going to, after my presentation, and I've promised you're going to be able to go back to go look at your contracts, look at your practices, and you're going to be able to spot the problems, and you're going to know how to fix them. But what are you going to do for all of the employees you currently have? It's not illegal to implement new agreements with a current employee, but you can't just say, take this and sign it. That's not going to meet all of the prongs of what an employment contract must be: offer, acceptance, consideration. So if you've got an existing employee and you want to implement a new agreement with new terms that weren't in place before, you've got to give them something new that they weren't already entitled to receive as consideration for those new terms. And it's not enough to simply say, sign it or you're fired. There is case law which says it is permissible to say that if you don't sign it, your employment will end on such a date. So if you're explicit and express, and you say, here's the new agreement, you're entitled to X amount of notice of termination under your contract. At the end of, let's say if your contract provides for 12 months notice for that person, at the end of 12 months of working notice, your employment will end unless it continues under these new terms and conditions. That is permissible, but anything short of that would be wrongful dismissal and wouldn't be consideration. Sort of offering not to fire them if they sign it is only consideration if you mean it and you're express. So what kinds of consideration could it be? Doesn't have to be much. The courts all talk about the absence or presence of consideration. There are no cases on what is sufficient. So, that boilerplate language, in consideration for the payment of X, $50 or whatever it is, and other consideration that everybody agrees is good and sufficient and received. It's in every agreement you've probably ever seen out there, commercially especially. That boilerplate language is there because $1 is enough. It used to be 1 pence or 1 peppercorn. People would come up to and their contract of employment, you'd open up a container of peppercorns, and you'd hand someone their fresh consideration. Here's your peppercorn. That's something you weren't entitled to receive. Take it, and now we have an enforceable contract. So it really can be that nominal. From a human resources perspective, that's probably not what you're going to do. You're not going to put $1 down as consideration, but it could be anything. It could be a $50 signing bonus. It could be a LCBO gift card. It could be 1 extra day of vacation that they can take in the next year. Anything they're not already entitled to receive. Another good time to implement new contract language and policies that'll have contractual force would be at bonus time, or would be at annual reviews when you're talking about increases. If your increase is mandated by some sort of a formula, that's not going to be helpful because they're already entitled to it. So you have to give them something more than what that automatic increase would be. But if your increases are not formulaic in that way, if you have some discretion, an extra penny per hour on top of whatever the increase on an hourly rate would be, that's consideration. A $50 bonus extra on that year is fresh consideration. And you're going to want to make reference to that up at the top of your agreement so that 10 years from now, when that person is let go and they challenge their contract, it says right there in the contract what the consideration was. Nobody has to go back to the HR file in the cabinet that's all covered in dust and nobody can find their documents anymore, right? A raise or promotion doesn't necessarily have to come with an increase in compensation, but usually does. But technically speaking, if it is something of value to that individual, that can be fresh consideration. Certainly something where their compensation goes up is recommended. You want to avoid backdating. Okay, so often when you have a current employee, you'll have a meeting with them. There's a posting for the job, a whole bunch of people vie for that position, and then you select your candidate, and then you might have them start in that position before you have your contract ready. That's problematic because now they've got the new job already. So you told everybody in the posting, here's what the bump will be in pay, here's what the new position will be, all of that sort of thing. And then they start in that role. You told them it's their job. They've accepted it. The contract has no fresh consideration. You've already spent your consideration when you gave them the position already. Okay. So you don't want to backdate. Instead, what you might do is have a signing bonus that's equivalent to the retro amount between what they would have earned had the rate already gone up, and what their rate would be under the new agreement if their pay is going up, for example. So don't increase them retroactively that way, but calculate a bonus on signing that's equivalent to the difference in pay as a signing bonus. That's fresh consideration. You also want to be aware of pre-employment work. And so this is an issue that comes up for current employees because they might start in that work before they officially take that role. For new employees, it's an issue. For new employees, there's another issue that we're going to discuss with a case that I'm going to talk about in a moment. But essentially, if the consideration for the job is the job, if the contract you want them to sign, if the consideration is this new position, if they've already accepted the job, you've offered it, they've accepted it, it's theirs. There's no new consideration. There's nothing for that piece of paper you send them after the fact. Ronco is a case that came out in 2006, 2008 from the Court of Appeal here in Ontario. Essentially, the employer gave 24 months notice to someone who refused to sign a new contract, that when their 24-month notice period in their contract was over, the new contract would be binding on them. The employee said, no, I'm not signing that. They waited 24 months. And then at the end of 24 months, they said, okay, sign it or you're fired. And Mr. Ronco said, well, actually, I told you I didn't want to sign this thing. My contract says I get 24 months of termination notice. You gave me 24 months notice that my contract terms would change. That's not the same thing. And so Mr. Ronco got another 24 months from the court of pay in lieu of notice after working for 24 months under his prior contract. So when we go back to that forbearance of termination piece, that's why you can't just give someone notice of the change. You have to give clear crystal notice of termination. At the end of this period, your employment will end unless it continues under these terms. That's clear notice. When an employee must receive fresh consideration, new employees, typically, again, that employment is the consideration. Recently out in BC, Adams and Think Labs, this was a fairly well-publicized case, partially because of how quickly the facts happened in this case. So this person received a detailed email after being recruited with a whole bunch of information about this position they were going to take. They accepted the position. The next morning, they got a copy of a contract to sign, which included non-competition, non-solicitation, termination clauses, all of that stuff. They sign it. Then we come to court. They sign it that day. So within a day of accepting the employment and then signing the contract, they challenged the enforceability of that agreement because they had already been told what their position would be in that email. They had already accepted employment in responding email. And then the following day, they signed a contract. There was no fresh consideration. So we have to be really careful when we're doing recruiting, whether we're using third parties, whether we're doing it ourselves. If we're communicating the detailed terms of an offer of a position, when we're trying to sell the job to the potential candidate, we need to be very clear. This is the outline of the position. Here's all the great stuff. When we offer you the job, you're going to get an employment contract that's going to set out the terms and conditions of your offer. That's the contract. And when in doubt, if we're concerned that maybe we weren't as clear as we should have been, or that the employee is going to try to assert we weren't as clear as we could have been, we actually add some fresh consideration. Just add some fresh consideration. That new employee is not going to take the position on day one that, well, I was trying to hoodwink you, so I've already accepted, I'm not going to sign this contract. That seems quite unlikely. What's more likely is you add a $50 signing bonus to a contract where there's some risk that you might have made an offer and had acceptance already in the sort of recruiting stage. Now they can't take the position. There's no fresh consideration. It's right there in the written agreement, and it's not something you would have offered them other than in this offer letter that you give them when you send the contract. You want to be aware of inducement. So inducement is where you've done something to induce someone, something more than just a sales pitch, something more than just encouraging them, telling them about how great your position is. Sometimes this happens when you headhunt someone away from another place, specifically going after them, using people in your company who have a personal or professional relationship with that person to go and scalp them from the other side. Giving them assurances and promises about how great it's all going to be, encouraging them knowingly to leave this secure, great job over here to come to your secure, great job over there. And the courts have held when that's what's happened, that's inducement. It goes beyond just persuasion or encouraging someone to come and work for you. It is going out there and making representations that person is then entitled to rely on, that this is a secure, great job, and that it's okay for me to let go of that other one. And when that happens, a court might say they're entitled to more notice of termination on the termination of their employment with you if it doesn't turn out to be a long-lasting position, even than what's in your contract. Now, if you have a well-drafted employment standards termination clause, which we're going to get into, or some other clause that makes it very clear what their entitlements are, inducement may not have a function there unless you've gone as far as to make a representation that could be tantamount to sort of a fraud, right? Like if you say, I actually had a client once that gave someone a contract. It said they get employment standards entitlements only on termination. The employee asked about it, wanted to negotiate the clause, and the answer was, oh, don't worry about that. We never enforce that anyways. We'll send you a much better offer, which is more like common law when we terminate you. Right in the middle of the recruiting session, there's the HR manager undercutting the very agreement that the lawyers in the HR department and their legal department had worked so hard to formulate. That representation is the sort of representation that a court will say, well, your contract might be okay, but that's not going to be binding after you say that, right? But otherwise, inducement generally only applies to someone who's entitled to common law reasonable notice, where the court is assessing what is the reasonable amount of notice someone should get on a termination of that sort in the circumstances. So in this particular case, this is a fairly older case, but it was Court of Appeal. Ms. Egan was given an awful lot of representations by people she knew in the industry to leave a very secure, long-standing senior job at Bell or in the Bell group of companies. And then she was let go very soon after she joined Alcatel. And so essentially the court said, this is the definition of inducement. We're going to increase the amount of reasonable notice that she's entitled to in the circumstances on the basis of those representations. Some of the interpretive principles, sort of fundamental here. Contra preferentum. This is a fancy Latin phrase, which basically means if you draft the contract, employer, and you're in a position of power, most of the time you send someone a contract, they don't get much negotiation power with you, sometimes a little bit more if they're senior. But in any case, you drafted the language. So if it's possible to read a clause in more than one way, one of those ways is better for the employee who didn't draft it, and one of those ways is better for you, and you did. Even if you insist, well, this is how we meant it, that's too bad. The court will apply the contra preferentum rule of interpretation, and they will say the way of reading this that's better for the employee, that's how we're going to interpret the contract, okay? Now, they're required to do that with employment contracts. That's the practice, okay? But they're not allowed to strain to find an ambiguity where it doesn't exist. And in Udin, which was a case that went up to our Ontario Court of Appeal, they said contra preferentum is not a means of finding the least favorable interpretation with a view to invalidating the agreement. So you're not allowed as a court, as a judge, to go looking for a way that really no objectively reasonable person would read the contract that way, just so that you can say, well, if I read it in that bizarre, twisted fashion, the contract won't be enforceable. That's not what the rule means. But if it reasonably could bear more than one interpretation, and one of those ways is better for you and one of those ways is better for them, it'll be based on what's better for them. And that includes if one way of reading it would violate the Employment Standards Act or other legal requirements, which would invalidate your agreement. Another interpretive principle are the factual matrix and objective intentions. And this comes out of a commercial case that went up to the Supreme Court of Canada a few years ago, where what the Supreme Court essentially said is, yes, the contract says what it says, but to understand what the parties intended when they entered into this agreement, we're allowed to consider the circumstances and what their understanding would have been of the words they chose. And that doesn't violate this rule called the parole evidence rule, which I don't want to get into in too much detail, but essentially there was an old rule, which is still applicable in some circumstances, which says that if the contract is not ambiguous, if you can read it and understand it, then you're not allowed to look at other facts and circumstances to change what your reading of that contract would be, sort of extraneous facts and evidence. What the court held here is we're not violating that rule by saying to understand what the parties intended, it's not a violation of that rule to find out what their circumstances were, to look at their industry. There might be terms of art that are used that everybody in that industry knows what this means. And if you don't know these industry terms because you don't go looking, you can't actually understand their contract. And so that's what the court was saying there. And that unfortunately means no matter how well you draft your contract to say there's nothing outside of this contract, there's no understandings outside of this contract, the court's not allowed to look at it. You can put in a clause that says, you know that case SATVA, ignore it. The court's not going to follow that because the Supreme Court of Canada has told them to understand what the parties meant. They have to be willing to look at those circumstances and subjective knowledge and situation of the parties who enter into the contract. This is an issue that I'm going to be we're now into the avoiding termination provision trap section of my presentation. Again, there will be a quiz during the lightning roundtable round. Okay, so be ready. This is the time to start taking notes and getting ready, guys. Okay, I know it's first thing in the morning, but I'm ready. I'm all driven. Okay, so there's a common law presumption that is rebuttable only if the contract clearly and explicitly and lawfully says you're either limited to the employment standards minimums or some other formula that's better. Otherwise, the common law presumes, even if you haven't put anything in your contract, that they are entitled to reasonable notice of termination of their employment under the common law, period, the end. Okay. And reasonable notice, as some of you, this isn't a presentation on what is reasonable notice, but essentially it's the difference between many months, most likely, of notice or pay in lieu of notice for an employee who under employment standards legislation might be entitled to a few weeks. So it is a vast gap in terms of what someone might get if you leave it up to a judge someday to figure out what would reasonable notice be versus the certainty of either a formula that's better than the employment standards legislation in your jurisdiction where they're working, or the legislation itself as a minimum. And that comes from a case in Hodge, MacDougall and Hodge from 1992 Supreme Court of Canada. So that principle that you can have lawfully an agreement that says you only get employment standards entitlements, that is legal. The problem is everybody took that message and went out there and drafted a whole bunch of different kinds of agreements, many of which really didn't follow that very simple principle. You can't have an agreement that falls below employment standards entitlements. And the courts have been developing over the last, now it's been 40 years, different ways of explaining to people in what circumstances their clause does fall below or might fall below. And what happens is when your clause is struck down for being less than what employment standards requires, it's gone. Not part of it, not some of it survives. All of it is gone. And you have common law reasonable notice as a term that gets then implied into your contract. And then you can go and have a fight about how old someone is and how long they've been there and what their position is and how difficult it would be for them to find reemployment and whether they have a duty to mitigate and all those fun things we fight about when we don't have a contract that is clear, enforceable, and valid. And then we can send that demand letter response, which just says, here's an offer of a few $1,000 for a release. We like our contract. You can go pound sand. That's my preference. But if you don't have a good contract and you don't have a good process, you don't have that strong footing. You don't have that leverage in negotiations. Waxdale proof. That's the first step. That was probably the most recent publicized case. My partner Landon did not draft the language that was at issue in that case, but he did argue that case before the Court of Appeal and tried to get leave to the Supreme Court. Certainly, I think in hindsight, that employer if they had gotten some advice or come to one of these sessions, might have drafted their contract otherwise. But ultimately, what we draw from Waxdale is that the general understanding that we all have or had before the case, that in the termination clause itself, that is applicable in that circumstance, if there's something that falls below employment standards, then your contract will fail. Waxdale made it very clear. It sort of brought together cases that had been fomenting for many, many years. And it said, the Supreme Court in that case said, you have to read termination provisions as a whole. Anywhere in the contract that there's language that affects someone's entitlements on termination, that is part of your termination clause. Even if it's in a completely different section of your 10-page contract, it's part of the termination language you've chosen in your contract. You're the employer, you drafted the thing. And so if there's probationary language on the first page and a termination clause on the 12th, that's all the termination language. It's all together. And if anywhere in your contract there's language that deals with the termination that would be unlawful, even if it's in the just cause clause, and in the without cause clause, you've got perfectly lawful language that limits someone to employment standards. It might even be a little bit more generous. If you've got a clause that in the situation of terminations for reasons, whether it's for cause or something else you've used to define it, if that falls below employment standards, your contract is void. In Waxdale, that's what happened. So when you have a clause in Ontario, we don't have an Employment Standards Act that says just cause for termination takes away someone's right to statutory termination pay, severance pay, and things like that. We use the phrase serious intentional misconduct that hasn't been condoned by the employer. So if you reserve the right to terminate for just cause in your contract and give someone nothing, you've implicitly reserved the right to terminate for reasons that under the common law might be just cause, but under the statutory definition weren't being bad on purpose. That's what the statutory clause really says. So if you reserve the right to terminate implicitly for common law, for really bad performance after multiple warnings and coaching, they haven't turned things around, that might be just cause under the common law, but it's not serious intentional misconduct that hasn't been condoned. So they're still entitled to employment standards. So if you reserve the right to terminate for just cause, you've reserved the right to violate the Employment Standards Act. And that's what happened in this particular situation. A few other important cases that have come up that I want to take you through. This one is actually being argued on appeal today, the Dufault case. So this was an interesting case because essentially the employer reserved the right in its language to terminate at any time for any reason. And it doesn't matter the language specifically that they used, but essentially it's the company may terminate at any time, or we may do so, or we can do this, instead of if the company does this. And so it was essentially reserving the right to terminate for reasons that might be unlawful. It expressly said, we may do so, and when we do so, we're only going to give you your employment standards entitlements. There are some situations where the Employment Standards Act or other legislation makes it illegal to terminate someone's employment. So reserving the right to terminate, we may terminate your employment at any time for any reason, that's effectively implicitly saying, I can fire you for illegal reasons and then only give you the Employment Standards Act entitlements. That's not okay, according to the court in the trial court in Dufault. And again, they're arguing that appeal today. So we may find out in a few months whether that decision holds up. But for now, that reasoning is going to hold, that you cannot reserve the right to terminate for unlawful reasons or implicitly for unlawful reasons, and doing so renders your termination clause invalid, and you now owe that person common law reasonable notice. So a very simple flip there would have been to say, if the company terminates your employment for lawful reasons, or even if you omit the word for lawful reasons, just if the company terminates your employment for any reason, here's what you're going to get. You haven't reserved the right to do so, but you've said if we do so. So you see the difference between those two formulations. One is reserving the right implicitly to do something that might be illegal, and one is just saying what happens if. I guess we'll argue that in Dufault 2 maybe, or something in a few years. Carell was another decision. This one came from Alberta. But there's a quirk in the Alberta legislation where, unlike in Ontario or other provinces where there's a provision which says if you provide a greater right or benefit, that's enforceable. And then you might have that, those arguments about whether you've offered someone a greater right or benefit under your contract than what the statute requires. In Alberta, there's explicit language, like elsewhere, about what someone's entitlement is on termination, but they also explicitly incorporate common law as an option. And so what happens essentially is if you only say on termination, you'll only get what the Alberta Employment Standards Code requires, you've implicitly said, well, the Employment Standards Code of Alberta also says that if we've given you common law reasonable notice, that we're going to give that to you and it's part of your contractual entitlement. So what ends up happening is you've incorporated this restriction, you think, but implicitly you're saying, if we haven't taken away your right to common law reasonable notice, that our contract promise to you is a greater right or benefit. We're promising, and now it's enforceable under the legislation in Alberta. And so the meaning, it's not illegal to say that in your contract. It's just not going to have any effect. So you need to say both sides of the coin. Okay? You need to say, number one, that you're only going to get the minimum requirements of the statute and nothing further under the common law. You have to say that. And if you don't say that, then you're going to have a problem. In Alberta, it's probably even a better idea if you want to have a specific agreement for Alberta to make reference to the section in Alberta and say, we're not giving you anything further under that provision of the Employment Standards Code. I think that might be overkill, but for people who are really worried about this line of case law, that would be an option. You want to Benson-proof your agreement. Benson is basically a case about fixed-term contracts without early termination language. If you have a fixed-term contract and you terminate early without cause, you owe that person the balance of the contract, period, the end. There's no entitlement to reasonable notice in a fixed contract. Your entitlement is to the balance of the term. So if you have a 5-year fixed-term contract and you want to fire that person in year 1, you owe them 4 years of pay in lieu of notice, period, the end. And it's not pay in lieu of notice, it's just pay to the balance of their term. So the lessons from that are, A, don't use fixed contracts ever. They're always terrible. That's my best advice. So if you learn anything from this presentation is don't. And if you do anyways, despite my advice, make sure you have a properly drafted early termination clause that your employment counsel has vetted very carefully. And know that even with the best laid plans in a contract, all the cases that keep coming out, time will tell if that early termination clause is held up by a court, or if they say instead you owe someone with a fixed term the balance of their contract. So again, advice 1, don't use them. Advice 2, if you're going to ignore me, then at least get a properly drafted early termination clause and ensure it's enforceable with fresh consideration. Bonuses. So there have been some cases on bonus entitlement on termination. A lot of bonus plans or contracts will say you have to be actively employed when a bonus is payable or else you're not going to get entitlement. The courts use a compensatory principle when they decide what someone is owed on termination. And what they do is they try to put the employee in the same position they would have been had they worked out the notice. So the default is working notice, and the damages is pay in lieu of notice, right? That's the second step. It's the alternative. So when a court is looking at words like actively employed, that's meaningless because they're trying to put the employee in the position they would have been had they been actively employed. So they're going to calculate what that bonus would have been. They're going to assume they had worked for the 12 months or whatever it is of notice they were entitled to. And if the bonus would have been payable during that notional period of active notice, then it's payable. So what you need is a clause that makes express reference to periods of pay in lieu of notice that are notional notice only, and how you don't have to pay out bonuses that become payable during that period. You have to watch out for Laxdale. You have to ensure you don't forget to say, unless that amount of bonus would have been payable during the period of working notice required by statute. So you still have to say, like if you pay someone in lieu of 8 weeks of ESA notice, if their bonus would have been payable during those 8 weeks, it's payable during those 8 weeks, even if you've opted for termination pay in lieu. Because the statute says when you pay in lieu, you have to give them everything they would have received had they worked out those 8 weeks of notice. And that's statutory. So if you fail to explicitly reserve that is an exception, then you're going to have a problem and your contract will fall for Waxdale reasons. Sometimes you might think about defining just cause. That's only in a situation where you have a contract that offers someone something better than employment standards entitlements. If you don't have an enhancement on termination, don't have a just cause clause. There's no reason. If you're reserving the right to terminate and give them only what the statute requires, you don't have to say anything more. If they've done something that would take away their rights under the statute requires that you give them nothing. So all you have to say is, on termination, you'll get whatever the statute requires and nothing further under common law. There's no need to define just cause. There's no need to have even a probationary period built into your agreement. It's all baked into the statute already. It's unnecessary and it exposes you to risk. Some general provisions to address risk. We don't have time to get into each of these, could be their own presentation, but I wanted to mention them. Non-solicitation competition clauses, intellectual property and confidentiality, adherence to company policies. These are the sorts of provisions that often find their way into secondary documents that people either sign after they become an employee, or they might be appendices to the contract. Any document that might be enforceable, you want to be very careful and take a look at them. People often sneak in provisions that deal with termination of employment entitlements and requirements in these things that are really not part of the main body of the contract. But if you want these to have contractual force, per Waxdale, the court might look at them. They might look at this confidentiality clause where you've reserved the right to say that that's just cause for termination and they get nothing. It doesn't belong in that policy, but it's there. Now you might have your main body contract termination clause fall down for that reason. Saving clauses is one other point I just wanted to make briefly. So we have some clauses that cannot cure statutorily unenforceable terms. You can't have a clause that says, if we broke the law, ignore us. That's not going to work. So the key is not to break the law in the first place. And there's a difference between explaining something in a clause and having a clause that says, if we broke the law, ignore us. That's for the quiz later. You might see some examples of that. Thank you very much.